In BSB111, we're really going to deal mainly with primary legal materials. You need to be aware that there are other ways of finding out what the law is, particularly in the murkier areas of the law. We'll talk about what the murkier areas are as we go on. But we're really interested in the primary sources of the law, legislation and case law. Now, if you are going into a management position, almost without doubt at some point you will read legislation and need to understand legislation. Very critical to a role in management these days, no matter what your role. If you're going into, say, something like accountancy in particular, or certain areas of management, you're really more than likely to read case law as well. So understanding these primary legal sources are not just for lawyers. It's a really important skill for managers as well. So, primary legal materials. Okay. They're the direct sources of law, legislation, and case law, or the law made by judges. We're going to explain this in more detail over the next few weeks. Case law is also called common law. It's the judge-made law, and then the statutes, or the legislation, is the stuff that's made by Parliament. In terms of case law, yes, it's the decisions of judges in courts, and they're recorded and published. We have something in the law called the Doctrine of precedent. And what that means is if a judge at a higher court level says an issue should be decided a certain way, then you need to follow it. Stare decisis, we won't get into that, we'll maybe get into a bit of Latin later. But you really have to follow the rules that a judge that's higher than you in the court hierarchy says. And so that's one of the ways we get that certainty and consistency in the law, particularly through the common law or the judge-made law. So because of that, the published records or their reasons for a decision in case law are really important to understanding what the law is. If there's a conflict between legislation and judge-made law, so a judge might decide something a certain way, and then later Parliament passes an act which conflicts with that. If that happens, then the rules of Parliament supersede judge-made law. Okay? If there's a conflict, legislation prevails. And the reason for that, have a think why. Why? Because we elected these people to Parliament, and the idea is if they decide that what a judge did is wrong, then we need to be able to change what the judge said. We don't want to be beholden to these individuals and judges, and we need a way for society to change the rules that they make, and we do that through legislation. In terms of case-made law, some areas of law, there's an intersection between what judges say and legislation. Sometimes the judge-made law or the case law is really more interpretations of the act. And again, we'll get into this in the next couple of weeks, but if you have an act that says something in words, someone has to interpret and apply them. So even where we have a statute, we do have a form of judge-made law, the interpretation of those acts of Parliament. Okay, so what do you need to know to understand how to read legislation? So have a look at this particular slide. So what you can see is there are three key bits. One is the title of the legislation, so you can find it. Here we've got the Competition and Consumer Act. Second is the date, okay, when it was enacted, 2010. And the third is the jurisdiction. Was it a state-based or was it a Commonwealth-based piece of legislation? With those three key pieces of information, you're pretty sure to be able to find the act that you want as part of your research. Case-made law can be a little more complex. So what we have are the parties, right? The people who were involved in the dispute. And then we have this V between them to separate the plaintiff from the defendant. And the V is actually not versus. Okay, so you've got to remember that. Please remember that. It's pronounced and. So Donahue and Stevenson, then again we have the date, 1932, the law reports that it comes from, appeal cases, AC, and the page number. So again, knowing that information tells you who's involved, when the case was about, where it was heard, and where you can actually find it. Very important for reference material and often just to put things in context. So we're going to go through these questions, but have a think about them before we actually get to the lecture. So When we have case law, you'll notice that there were parties. How do we work out what the order means? Okay. So when we have these reported cases, the first time a case is heard, the person bringing the case who thinks they've been wronged is the plaintiff. The person answering the case is the defendant. They're defending it. Plaintiff brings it, defendant defends it. Now, what you'll see differently in criminal cases is that it's actually society that brings the case. And in the case of the Australian scenario, or in Australia, that is brought by the Crown. So we call the government, rather than calling it a political party or anything, we call it the Crown. And we often use the letter R. So that's where that R comes from. If you see R, then what you know is it's a criminal case, and that represents the Crown. Now the V, if you see R.V. Nicholson, the V is actually pronounced against. It's the only time it's not and in the criminal cases. Now what happens when you appeal? So just say there's a case, someone's unhappy with the decision and they decide to appeal it. Well, if there's an appeal from an earlier decision, the person bringing the appeal is the appellant, and the person opposing the appeal is the respondent. So if Smith sues Jones for a breach of contract, the initial case would be Smith and Jones. If Jones loses, so if the defendant loses and appeals, then the appeal case reverses the order and you get Jones and Smith. So that's why knowing the court that it's in, so it helps you understand if it's an appeal, will also help you know who is bringing the action and who is defending it. Because at the appeal section, the original plaintiff now has, to some degree, become the respondent. So they're defending it as the respondent. I'm not going to say they're the defendant, because the defendant is in our first instance case. Okay, so that's some way of looking at and understanding case law. Have a look at this citation to a case, the Crown and Clark, 1927. Think about some of those questions we'll go through so that you can understand how to find these materials. There are some wonderful sites for finding legislation. Wonderful sites, what am I talking about? Well, sites where you can get it. Really important sites for you to understand. Austlii is a really important site. comlaw.gov. Austlii, you can also get the legislation on, etc. So have a look at those sites. Try and find some acts that you might be actually interested in. And then we'll go on to how we can actually read the law. Okay, so welcome back to the last section for this week, and it's about reading the law. So I'm just going to concentrate on the slides for this one, and so help you work through how you might read the law. As I said before, this can become vitally important when you're actually in business, particularly around statutes, but also in case law, depending upon where you end up. So what we've asked you to do is to look at page 151 of your textbook. And to give you an idea, have a look at that page and look at the structure of what you can see around the Act, the Radio Licence Fees Amendment Act of 2007. You can see the title there, Radio Licence Fees Amendment Act. You can also see the date of assent, 2007, that we can see there, assented to on the 28th of May, so you can see when it comes into force, an important point to know when it applies and when it doesn't. And then you can see sections and subsections. So particularly you see section 1 is the short title, section 2 is commencement, section 3 refers to the schedules. So you can see that there are sections within an act, and we're going to refer to them a lot. So there's the key elements to look at in legislation when you see them. The name of the act, when it comes into force, the date of assent, and the idea that we have these sections and subsections. When we have cases, you can see that there's a lot more detailed information often in cases. So a case report is a judgment, and it includes lots of information, and part of the role of lawyers is to interpret that information and see the principles that actually come out of a particular case. And they've got a very famous case here, the Pharmaceutical Society of Great Britain and Boots Cash Chemists on page 154. That's where that starts. Often there are different judges, and even the judges can express different opinions and can express different reasons. And that's why, while we want clarity in the law, sometimes it's not very clear what the law is until there have been a few decisions that clarify the law. Sometimes, if there is more than one judge, each judge can provide their own individual judgment, even if they agree with each other. This often happens even when they have different reasons, or because they have different reasons for reaching their judgment. So we'll discuss that in more detail a bit later in the course. Now let's actually look at what we would see in a case. So here's a very famous High Court case about native title, Mabo and others, and the state of Queensland. You can see very clearly here that we can see the parties. You can also see that this was held in the High Court of Australia. You can see that both here and here from the case. You can see when it was held, 1991 to 1992. You can see the justices of the High Court that were involved, Chief Justice Mason and Justices Brennan, Dean, Dawson, Toohey, Gaudron and McKeown. Very interestingly, you would have seen recently in the press, we've had a new justice appointed to the High Court. And then it starts out with a summary of the facts. So the judges are giving an idea about what happened in the particular case. After we get through the facts, we can see a summary of the judges' decisions. And here we can see that the judges have different answers, okay, around different areas. So held by Mason, Brennan, Dean, Toohey, Gaudron and McKeown, Jawson J dissenting, so Jawson didn't agree. Okay. Then we see held by Mason, Brennan, Dean, Toohey, Gaudron and McKeown, this. Dawson J was of the opinion that, so had a different view. And then it was held by Mason, Brennan and McKeown, that, so you can see even within the decision, various elements are agreed differently by different judges. So we have this summary of the judges' decisions. And what we also have is the authority or the cases that were actually used to help us decide this decision. So this is like your reference list that we have in place. And we're going to come back and talk about more what does a reference list mean, what happens when judges don't agree, when we look at how we use case law. But just familiarise yourself with a case, the key elements of the case, and how you can read one kind of quickly in this summary area that we've just been going through.